Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru Tumarkin, as many may know. And I'm here today, as always, to join you and try to answer as many questions as possible. Anything relating to your employment, maybe you're given a contract you've got some questions about, maybe something's going on in the workplace. Perhaps you've just been let go or placed on a layoff and you're wondering what your rights are. But as I say, whatever it may be, just get your questions in and I'll do my best to answer them live here today. Just before some of those questions come in, today I wanted to start off by talking a little bit about employment contracts, one of the things that I just mentioned. Something very common nowadays, whether it be upon hire or maybe even into your tenure, into your actual employment work relationship, you're given another contract and you're asked to sign it. A lot of questions that I tend to face on a daily basis deal with those types of things. What's in them? Should I sign? Should I not sign? Should I have one? So I just wanted to address maybe a couple of the main issues or pieces of advice I think I can give when it comes, generally speaking, to contracts. So in general, when you think of a contract, you might think that you're getting a benefit by signing it, having your employer sign it. But for the most part, contracts are aimed at generally protecting the company. They will in the contract confirm how much money you're being paid. They'll maybe talk about your job, the duties, who you report to, the hours you work, maybe how a bonus structure might look like or commission structure. So in the sense of those items, it can be good to have, of course, written clarification on all of that just to be safe. But then beyond that, the rest of the contract, other than confirming those items, typically has clauses in it that will be aimed at protecting the company. So it could be a termination clause contained in your contract that says, if we ever were to let you go, this is how much we're going to give you. Most often, they're trying to give you just the bare minimum. So that's usually against your interest. You've got things like non-solicitation agreements, potentially being against your interest. You've got other little lines here and there throughout a contract that might allow the employer to put you on a layoff temporarily, that might allow the employer to change the terms of your employment. So you always want to be mindful of this idea. And before signing anything, for those reasons, and just to make sure that you understand clearly what's being said and what you're potentially going to be held to later on down the road, you definitely want to hold off from signing without first contacting an employment lawyer. So you want to get in touch with us, and we can at least take you through the contract and highlight, here are some red flags, or this is what this could potentially do to you, so that at least you can make an informed decision. But in general, the idea is that they're not typically going to be in your favor. And the more lengthy the contract is, the more pages that it has, even more opportunity to, for the employer to include further things in there that are to its benefit. So it may not be as bad to have a contract that's maybe only 1 or 2 pages, probably a lot less risk that there's going to be problematic language in there. But when you're looking at 10, 15, 20 page contracts, usually that can be a potential concern, and I think all the more reason to have those things reviewed. You don't actually need to have a written contract in place. There's another, I guess you could call it a misconception or an idea out there that it's something that's required. You can still very well start an employment relationship on the basis of a handshake, or just through, oral or verbal words. It's the disadvantage of that is that it may not be as clear if there's ever a dispute later on as far as what you were assigned to do and what you're paid and all that. So there is a bit of risk there, and that's why it's always good to at least get those details confirmed in writing, if not through a contract you sign. But in most cases, just having a handshake and going about your business and doing your job from there can actually benefit you more so than having a written contract in place, because you're not going to have all of those potentially problematic sections or clauses in there limiting rights of yours that otherwise would stand up. It's usually you have a set of rights, and that can be lessened or curtailed with a contract. If you don't have a contract, then there's going to be more of a potential in terms of all the different rights you may have, whether it be for things like severance or anything else for that matter. So don't think that you need something formally in place. And a lot of times, and then maybe even most cases, it could be to your benefit to avoid having there be this lengthy written contract. Now, your employer can't also accept you to sign a new contract. So I mentioned earlier that sometimes you'll be in your job, maybe working for 3, 4, 5 years, and then your employer comes to you and says, here's this new contract we want you to sign. Here, go ahead and sign it. In most cases, the reason they're offering a new contract, an updated contract, is potentially because they've added in more language that could benefit them. And a lot of time there actually isn't any additional benefit going your way. And that's something to be wary of, where you're asked to sign something, but you're not given anything in exchange for signing it other than just keeping your job. I see a lot of times where this happens, it's a bad thing for the employer because they can't then rely on that second contract just for the fact that the person signing it, the employee, got nothing out of it other than continued work. So I think that's more food for thought for the company side of things. They want to, if they're going to have a chance of enforcing a contract that they give to someone and have them sign mid-service, they need to be giving the employee an additional benefit. And sometimes I see in these contracts mentioning of an employee getting a $50 gift card or a $200 cash bonus. And so the reason the companies, again, are doing this is because they know they have to give something. So as long as they give you $50 or even less than that, they can say at the end of the day that you got something out of it, the cash or the gift card, and they got something out of it, which is adding in maybe some extra language that could limit potential rights down the road. So you want to be wary also of this. Am I getting something, a benefit that I don't already have in exchange for signing this new contract? But just like an initial contract, I would still be recommending to those out there that are given a second or third or fourth, you want to be also making sure you get in touch with us so we can kind of go through whether you even have to sign the contract, because there are a lot of situations where you as an employee in that situation can refuse to sign the second contract, and you can insist on the first contract staying in place. So there are potentially more rights available for situations like that. And again, all the more reason to get some advice on the topic. Now, having said that, I've got another thing I wanted to talk about off the top of the show, but I will get into some of the questions now because I want to make sure I answer as many as I can. So first comment, I think, is from Justina on LinkedIn, who's asking to contact her regarding a salary that's not been paid by a Canadian company. So just on the face of that, obviously it looks like a big concern. If somebody's owed a salary or wages, you've earned it, maybe you've worked out the days, you've got a contract that says this is how I'm going to get paid, and the company doesn't pay you, that alone, I mean, first of all, that could raise up a bunch of issues with the Ministry of Labor, and there could be steps taken to essentially have the ministry step in and ensure those wages are paid, because that would be generally a violation of employment standards legislation. So that's number one. But number two, the fact of an employer refusing to pay somebody their earned and owed wages, that alone also could trigger a termination, and what's more so known as a constructive dismissal, because of course you wouldn't generally be consenting to something like that, a change like that. And so you could treat that as a moment of termination, and so not only get your wages that you're owed, but also potentially go after that company for severance, as though you had been terminated sort of around the time that the wage wasn't paid. So for Justina or anyone out there that's in a situation like that, absolutely, you want to contact us. So you can definitely give us a shout. We can set up consultations throughout the week and at least go through the steps needed to kind of get what you're owed. And if we need to get involved to any further degree, we can talk about that as well. But thanks for your comment. I've got another one in from FP on Reddit, who's saying that they recently gave notice to their employer that they needed to take some time, some unpaid time off. and take an extended vacation out of the country. They'd be gone for 8 weeks. The company denied the request. They said they can't accommodate this due to short staffing. They didn't fire or terminate this individual, but can they let me go for this? So they can in general. And I say that because employers can let you go for almost anything under the sun, so long as it's not something to do with human rights, which clearly would be discrimination. Employers can pretty much get away with any reason, even if it's not the best reason or a smart decision or smart rationale. So if somebody goes on vacation for a period longer than they're entitled to, and the company denies it, and they say, that they can't do it because they have this short staffing issue, and the person insists or just in any event proceeds to go on the vacation for 8 weeks, then the employer could definitely come back and say, this is what we said, we're letting you go. Now, if they let you go, it's not to say that they have just cause to let you go for that necessarily. In fact, probably they don't. So if they're going to let you go for not, helping them out in this time of need, if that's true, then they would still have to pay you your severance. And that could be as much as 2 years of severance. So there is that distinction that, yes, employers can let people go for any reason pretty much, as long as it's not, extreme bad faith or discrimination. But if they're going to let them go for something short of that and they don't have cause, they still have to pay you your severance. Now, there could also be some issue in terms of FP's situation regarding what his vacation entitlement was, regarding maybe the reason for the vacation. Again, if there's any health-related reason, that could potentially be an act of discrimination on sort of disability-related grounds if you've got the backing from your doctor to take an extended leave. So there are definitely some potentials there for bad faith. But at the very least, you'd be looking at your severance, which could be quite significant. I've got another one in from Brittany, who's saying that their employer placed them on a PIP, performance improvement plan, because they said that they have an attitude. Then Brittany mentions being on the spectrum, having provided doctor's notes, and this is why Brittany believes they were let go. Okay, so they put you on a PIP, they said you had an attitude, and then after that, they let you go. Fired you for cause, in fact. So to me, on the face of it, that sounds very egregious. I mean, obviously, if this so-called attitude problem has anything to do with being on the spectrum or as a byproduct of that, or there's some sort of overlap between those two things, and particularly if they know about it and they've been given notes and they've had maybe discussions with you, and so they can kind of understand, there may be some overlap here, that may be the reason, then to let somebody go for having an attitude is, you could definitely argue, is discrimination as well, on the basis of a disability. It would just be like if I had injured my leg and then they knew about this and then they put me on a performance improvement plan because I was moving too slowly in the office, knowing that I have a broken leg and that I can't, be as mobile. So the same sort of thing, they could let me go because I'm being so-called too slow, but they're obviously just disregarding the fact that has to do, at least in part, to my disability. So employer could definitely get in hot water. I don't know, why they let you go for cause as well. As I mentioned before, most of the time, if someone's let go, it's on a without cause basis, unless the employer believes or has some sort of evidence that would show you've committed some capital error within the workplace. Because to meet that threshold for cause, there's a very high standard, right? So if you're stealing from the company or you're assaulting people left, right, and center, I mean, those are going to be clear instances of cause. But there are, unfortunately, a lot of cases where an employer thinks they have cause, but they fall, extremely short of that threshold. And also to let somebody go for cause due to attitude, I guess my question would be, how bad is the attitude? And again, they're playing with fire if there's that overlap between your status and the alleged reason for your dismissal. So Doesn't seem to me like they have cause, although that might be something we can flesh out further in a consultation. Definitely seems on the face of it there's discrimination. So, I mean, you could potentially be looking at, of course, your severance for the years you were there, but also punitive or extraordinary damages for the way or the manner that you were let go. Because it's not just the fact that you were let go, but it seems like it was particularly egregious. So I definitely recommend, Brittany, you give us a call, because, yeah, it seems like there's a lot there to be had. And, yeah, I wouldn't want the employer to get away with it if, in fact, what you're saying is essentially the case. But thanks again for your question. I've got another one in from Martina, who's saying or asking, what are our rights to working remotely and being asked to be on site now, but child care obligations do not allow for this? Okay, so there's a couple situations. If you have a job that you started at working remotely from the very beginning, and you're doing that, let's say, full time throughout the week, and then all of a sudden the company's coming in and asking you to work on site 5 days a week, as an example, that to me would be a clear breach of your employment, because you started as a remote worker and it's never been anything different. And I think if an employer were to insist on you coming on site, they would have to show that there was some ability of theirs to put you on site, whether it be in a contract or because you worked on site before. But even in that scenario, not only are they breaching your contract because you're a remote worker from day one, but they're also being particularly bad faith given your mention of the childcare obligations. It's kind of like in Brittany's situation. I bring up the fact that I have childcare obligations or a disability or anything under the human rights umbrella. That's going to put more pressure on the employer to accommodate me. So not only, in this case, Martina, would I say it's just a breach of my employment agreement because I've worked remote from day one, but clearly you have knowledge of me having these obligations. This is why this arrangement works out for me. And so I'm asking for you to accommodate me. And if they don't, then just like in Brittany's case, that could be a failure to accommodate. That could be taking actions that are against that particular status. So that's number one. If you're a remote worker from day one, if you started off in the office and then you transition to working remotely from home, even in that scenario, you could have a situation where maybe for the first 10 years you were in office, and in the last 3 or 4 or 5, you've been remote. Your terms of employment at that stage, I would say or argue, have changed. You're no longer an in-office employee because you've been working remotely for such a long time. And so at that point, I would even argue that, whenever this is happening, you are a remote employee. And so my comments for the first situation would stand in that case. But let's just say you have never worked remotely, or you've only worked remotely for a very brief period of time. The fact that you're bringing up childcare obligations, assuming it's all legitimate, of course, that is still going to generally require the employer to accommodate you, especially if you can do your job from home. It might be one thing if you can't do your job from home, it's just not applicable. But if you have been doing it in the past, even if it's for a few months, not necessarily a few years, and you've demonstrated that there's no issues working from home, then that, combined with the fact that you've mentioned the childcare obligations, would still put a lot of pressure on the employer to accommodate you. And if they don't, they still are going to be opening that can of worms as far as there being potential discrimination, that being a constructive dismissal itself, a breach of your contract, entitling you to severance, just like in Brittany's case. So there are, I think, a lot of avenues for you to go down, regardless of the situation you're in, whether you started remote, switched to later, you were always remote, never switched. I think either way, to me, it seems on the face of it that, again, the employer is being unreasonable, which may force your hand and may actually lead to you leaving the scenario and getting your full severance. But again, give us a call first so we can kind of talk it through just before you commit one way or another, or have any major communications back and forth. The last thing I would want is to, have you do or say something that might prejudice things later on. But thanks for your question, Martina. I got another one in from Neil, who's saying that their employer is starting a quote unquote enrichment program, and they want us to participate in volunteering and team building once a month. but it is on a weekend and it's unpaid. Can they make me do this? So no, they can't make you do it. Doesn't seem like it was a requirement or a term of your employment before. So obviously, from one perspective, you would say, this is a change to the terms of my employment. I'm not agreeable to doing it. Now, what happens from there would be the question, because your employer could say, you know what, you're right. This is something we've added. It's a new initiative of ours. We do want you doing this thing once a month unpaid. We understand why you don't, and we're not going to, be upset with you in terms of your response, but we're going to let you go. And so then the employer could essentially let you go and just say, we're letting you go because we want to build a team of team players that do these activities once a month. And that doesn't have to be the best idea, the best rationale. That may make not any sense to you. But it could still be a reason for why they let you go. And as unfortunate as that may be, and as sort of minor as you may consider that to be, which I would agree with, it's still not illegal for them to let you go for not wanting to involve yourself in these activities. Now, they would have to pay you severance. So it's not like they could say, oh, because you're not showing up once a month unpaid, that's some extreme breach of our code, and we're letting you go and we're not paying you a dime on your way out. That would be definitely taking it too far, and that's where that employer would get into hot water. But if they say, we just would have preferred you to do this, it's unfortunate you don't, this is what we want to do going forward, so we're going to let you go, and here's your full severance, then that's probably as best you can do. But whether they give you your full severance, of course, I'm not going to say that. Most of the time they don't. So if that were to happen, I definitely suggest you give us a call, because there's a very good chance they could try to undercut you or give you something on the lower end of what you might get from a court. But yeah, unfortunately, if that's how they want to run their business, so long as they don't strip you of those severance entitlements and maybe other things, unfortunately, they can decide to kind of run their business in the way they want to in that regard. Again, you've got to involve or at least bring up this idea of discrimination. So it's not to say that maybe that's not existing in your case, Neil. Maybe you can't go to this exercise because you have childcare commitments, or because you have a disability that may prevent you from doing that particular activity. So there's always a potential overlap there, but you do need to kind of establish that first. Otherwise, I think the most you'd be looking at would be, at the very least, your full severance. I've got a follow-up question from Martina. Just the situation involving remote work and being asked to be on site. She's asking, what are the best steps to move forward to let them know I'm not quitting? I want to continue working as I have been, but have no childcare for toddler. Yeah, again, I would say, Martina, give us a shout. I think in general, the sentiment is correct. I mean, you don't want to quit for sure. You don't want to be saying I quit, because even if you're quitting due to some breach of theirs, that could just be ended up being interpreted as you resigning, and then you don't get any severance. So you don't want to send any communication like that yet. But the sentiment I agree with, that you say, I'm not quitting. I still would like to work as I have been remotely. I've been doing my job fine. I'm willing to continue that along as it has been. I'm agreeable to that, but I'm not agreeable to, this demand of working on site 3, 4, 5 days a week, whatever it is. And, kind of just drawing the line in the sand and asking them to let you know ultimately what is their decision. Are they going to accommodate, or is it going to be their way or the highway? Because at that point, you've said your piece, you've made your stance clear. They've come back and now given you the full range of options, whether it's one or more. And now at that point, you either have to decide, do I want to say yes to what they're asking? And if I do, then you're probably not going to be able to go back to remote work. So that could be a problem there. Or do I want to say no? I've given them a chance. They've made it very clear they're not interested in doing it. And they're basically saying, if you want to keep working here, you have to be on site. And we're not going to pay you if you're working remotely. Well, then, yeah, at that point, you could communicate to them that you believe it's a constructive dismissal, that, and basically go after them for severance and maybe then some. But I would suggest you getting in touch with a lawyer just so they can craft those types of messages for you. But again, I do agree with the general sentiment. So you're kind of along the right path there in terms of your comment. I've got another question in from Eleanor, who's saying that their manager has said that the reimbursement for Eleanor's cell phone and mileage is going to be stopped. Can I just stop this kind of compensation? What are my rights in this situation? So it seems clear based on what you're saying that there is a change to the terms of your employment. So that probably isn't disputed. So I don't think there'd be any argument there from the employer. The question is whether the employer can make that change. There are certain changes employers can, I guess what I'll say, get away with, and then there's other changes they can't. So when it comes to, let's say, money, say you're making $50,000 a year, and your employer comes to you and says, we are cutting your wage to $40,000 a year. So you're taking a $10,000 annual loss. That's 20% of your 50, that 10. A 20% reduction in someone's wages in that sort of a situation is going to be considered a constructive dismissal that you can say, I'm not agreeable to. This is a termination. This is essentially a constructive dismissal, and that would entitle you to severance, just as though you were let go. And any other entitlements in the event of a termination. If I'm making $50,000 and they cut my salary by $5,000, so only 10%, then it becomes a bit more debatable or questionable whether a judge or a court would say that that is a big enough change to the terms of the employment. So there's no debate that it would be a change downward, that it would be a pay cut. But when I said earlier that employers can get away with certain changes, if the change they make to your employment, even if you don't consent, is considered minor, or at least more minor than something that would normally entitle you to a severance package, then there are situations where employers can do that. And the courts will say it was a change, it just wasn't big enough of one to have the employment relationship just stop and for you to get your full severance owed. So usually the change on the dollar front has to be around at least the 10 to 15% range, if not closer to 15. So if the cut to your cell phone and mileage reflects, let's say, 5% of your overall wages or earnings for the year, there's going to be more of a struggle in pushing back and insisting on that not happening. Otherwise, you get your full severance. If the cut is, like I said before, 15, 20% worth of income over the year, then that's going to pretty clearly entitle you to saying that that's a constructive dismissal, and I want, my rights in that situation as though I've been let go, and then potentially go after the company for that. There is also the side potential of getting some extra damages just for the fact that it was a breach that you didn't consent to. Sometimes there is, though, a contract you may have signed that talks about cell phone and mileage and all these different items. And sometimes companies say that they're making the change because they think they can do so under the contract or the way that it's worded. This is sort of a point that generally applies to everything, really, and anything I've spoken about before so far today, is that you also want to look back at any contract you might have signed to see, is there something in there that says we have the right or we reserve the right to make a change here or there. So that's another little X factor there. But it does often come down to, what kind of a hit exactly are you taking? And how does it sort of relate to your overall earnings? So maybe, Eleanor, you want to get in touch with us as well, set up a consultation, and we can kind of talk it through and just sort of see what your options are. Because the last thing I would want is for someone to start communicating with their employer, thinking that they have them dead to rights, that it's a guarantee they're going to get their severance, they're going to get this, they're going to get that, say a bunch of stuff, and then find out later on that things are a bit more complicated or complex, maybe not straightforward, a little bit more nuanced. And now they've kind of dug themselves a little bit of a hole and may prejudice their rights. So that also is just something generally that applies to everyone I've addressed so far today as well. Again, all the more reason to give us a shout. But with that said, that's going to be my time for this afternoon. I do thank everyone for showing up, for bringing in their questions. For those that I did answer questions and mentioned to get in touch with us, definitely do so. And for those that I didn't get around to, my apologies, but we do have these Q&As going on all the time. You see right there down below. Wednesday, October the 1st with Mr. Samfiru. So he'll be there. He'll answer any question you've got. definitely tune in then for those that I didn't get around to answering. And as far as today, do have a great rest of your day. Enjoy your afternoon. All the best. Do take care.